So thank you very much indeed for joining this morning. There's just a few more people coming in, so we'll just wait a couple of minutes whilst people join this webinar. We're going to be talking today about artificial intelligence and intellectual property. This is a subject, obviously, that there's been lots of debates about. Our focus today is going to be very much on patents, a little bit on copyright. We're going to talk about some of the big discussions that people have been having about copyright infringement and the like. But first of all, I'm going to talk you through what are the basic principles of artificial intelligence and intellectual property protection, what you should be thinking about in the event of protecting any innovations in the field of artificial intelligence, and how we move against. Now, if you have any questions, there is a Q&A button at the bottom, as you can probably see. Please put your questions there, and I'll try and reserve a couple of minutes at the end for any questions that you might have. Of course, you are welcome, if you want, to actually contact me at a later stage, and I will give you my contact details at the end of the session. So thank you very much. We're now at 10:01. So what I think we'll do is we'll start the session. Firstly, I'd like to acknowledge the support of the European Commission through the European IPR Help Desk in the preparation of this webinar. This is a webinar that we have given it in the past to some groups, and we will be doing it, following up in a few months' time with a more advanced version. So please do feel free to keep an eye out for the future versions of this webinar through the European IPR's Help Desk program. This may be a little bit about me. My name is Robert Harrison, so originally of British origin, though I actually live in Munich, Germany these days, and I'm also a German citizen. I'm a qualified physicist. I actually have a PhD in photonics from Sheffield University, after which I joined the European Patent Office and then later got my intellectual property law diploma through when I was working for IBM. Basically, these days, I advise a lot of startups as an advisory board member, help them with intellectual property strategy, how they can actually protect their innovations, particularly in the field of informatics and deep technologies. So I guess the majority of you actually understand and know a little bit about what artificial intelligence is. Just to put it just to give you a little bit of an idea, of course, we have these massive databases these days, which we use to train our AI models, and that we're then able to use the trained models to actually then input some new data and get some answers out of that data. That's it in a nutshell. I don't really intend to go into that in any more detail, but let's just take that as understand it, that most of you will actually understand where we are there. So the question is, how can I actually protect them? Now, some people say, you can't really protect artificial intelligence innovations with patents, or maybe you shouldn't. We know that in Europe, computer software as such is not can be excluded from patentability. But of course, that doesn't actually mean that you can't file patents on it. Some of you may have actually seen or taken part in webinars over the years in which a patent office have actually explained to you how, if you use the computer software as an implementing tool, then you can still get patent protection. And that just shows it these days here. Just look at the data sets that we actually hear. This is from the Center for Security and Emerging Technology, going up to 2021, which is the latest data that I was actually able to find from a reliable source, which just shows you that massive number of patent applications that have arisen. Now, about half of those are coming from China. There is a little bit of a question mark about how good and how the quality of the Chinese patent applications are, but about the rest of the other half are actually coming from the United States, from Europe, and from a number of other countries around the world. So what we're seeing is not only a rise in the use of artificial intelligence, in the number of papers that are being published in artificial intelligence, but also the large number of patent applications that are actually being filed. Who are the companies most filing patents? Well, not unsurprisingly, Tencent, Baidu, Ping An from China are going to be with us. IBM, of course, have a number of patents on AI, as do Alphabet, Google, and Microsoft. And then the only other company there we'll see is Samsung, of course, coming out of South Korea. So how do we regulate artificial intelligence? Well, some of you may have heard of the European AI Act, the Artificial Intelligence Act, that's come into force in 2024. And what was quite clear from that European AI Act is not only does it regulate how to use artificial intelligence, but there's also quite a strong emphasis put by the European Parliament on the need to protect intellectual property in the field of artificial intelligence. What the European Parliament did not want to see is basically a free for all, where it was thought that everybody could misuse, abuse, use intellectual property for their purposes, but they wanted to have a quite clear guidance that you can protect artificial intelligence innovations through intellectual property, and that you need to be able to respect the rights of other owners of intellectual property. So that's a very clear thread that has gone through the European Parliament's discussions, and it's probably the consensus within the European Union. I think some of you will have heard some of the debates that have in the United States. We've got some of the big companies basically calling for a complete overhaul of the intellectual property system in order to enable artificial intelligence. I won't go into the rights and wrongs of that at this stage. I have my own feelings on it, but I think it's quite important to understand that we are not going to have a free-for-all for intellectual property in Europe, even if that might be the direction that is going in the United States. So, IP and artificial intelligence, how can we actually protect our innovations? Well, part of it's about data ownership and the use of databases. Obviously, contractual rights are incredibly important, as I'll come to, and then we'll talk quite a lot, maybe about 20 minutes, about how we can use it to your patents to protect your innovations. So let's move on a little bit. So what about data? Can you actually own data? Now, there's a real problem here because different countries within the European Union have different concepts about protecting data. It's not like you own your computer. It's not like you own your car, or the bank maybe owns the car. It's not like you own your house, or the bank owns your house. Data is something that's very, very intangible. Data about myself, my name, Robert Harrison, my age, my sex, my medical records, that's not really owned by me. The most I can have is a certain amount of control over it. And the European Commission has tried over the years really to try and regulate how data is used. They basically left aside the concept of ownership and much more talked about when can you use it, under what circumstances can you use it. So publicly generated data should be made available as open data for everyone to use. Privately generated data, well, that's up to you to decide how you can actually use it. And within that, we have the Data Governance Act, we have the open data regulations. There's a whole load of regulations, and unfortunately, I just simply do not have time to go through them. But the essence of it is that if you're a public authority working using public funds, you will have to make your raw data available for everyone to use. You don't necessarily have to make available your curated data, but at least the raw data you need to be available. On the other hand, when you're a private company, that basically is up to you. You are in position, you can control the use of that. That's somewhat simplified, I should actually want to talk about. Of course, some people then say, well, doesn't copyright apply to that? I mean, copyright applies to computer programs, obviously it applies to music performances, it applies to books, it applies to presentations in the internet. What about data? Well, that's generally excluded. Why? Because we need to have a certain level of creativity required for copyright protection. So the fact that I'm called Robert Harrison is actually due to my mum and dad naming me Robert Harrison on my birth or a few days before my birth, for example. That's not really creative. In fact, my forefathers is called Robert Harrison as well. That's where they got the name from, as many of you as well. So it's unlikely you'll be able to protect the data per se. You might be able to protect collections of data. We don't really have time to go into that. That's people who collect protected, for example, horse racing data or medical data. But the individual data items, whether you get it, for example, from sensors in a factory, whether you get it from names from the telephone books, that probably cannot be protected by copyright. But of course, the other important thing is that software is protected by copyright. That's under what's the International Berne Convention, and that actually goes back to a European Union law that was actually came, I think it was about 1992. It's just about when I was training to be a patent attorney. My boss at IBM at that stage was heavily involved in setting out clearly that computer programs can be protected by copyright. And that's something that we are quite used to these days. So particularly for the use of data, some of the most important protection is going by contracts. Now, we're all used to using contracts now in the internet. You want to, for example, I can see a couple of you are working in patents field. You will know that if you want to use the patent databases, the commercial patent databases, they're quite expensive. You have to sign a contract. You're told what you can use the data for, how you can use the data. That's certainly fine. We can certainly all work with that. But this goes beyond that, for example. If, for example, you want to download or use data that's provided by a company, they might be prepared to give this to you. Might not give it to you, but license you to use it. They will probably want to have some money for doing it. So one of the things that the project that I worked on about 5 years ago was medical informatics data about the functions that certain proteins had in connection with certain illnesses. And the company I was working for had established this massive database, partly taking in publicly available data, partly data that they had done from their own experiments. And they were then prepared to license this out to other people to be able to use the data for their own purposes. The company concerned was also trying to develop new medical medicines using this data. And we'll come to that in a moment. But what they were also doing, they had another business stream, which was basically, we don't know all of the potential applications, but what we are prepared to do is actually provide you with the data. And their contracts talked about the use of the data. They talked about curation of the data, how you could exploit the data, and how you could exploit the results at the end of the day that you got from the data. And they said basically, well, you can pay, you can have a pick of data, you can take it out, or you can have a time-based model for a couple of hours working in our database. All of those are possible. What you are not allowed to do is download the data. And they had certain measures built into that because they didn't basically want somebody to replicate the system that they were using. Now, those contractual arrangements are fine for data, but then the issue becomes very much along the lines, can we actually protect our innovations that we create from this data in the form of patents? Well, the answer is basically yes. Now, some of you here will know and will have experience in filing a patent application. Just very, very quickly, what we'll often do is we'll file a first patent application, whether that's in Austria, in Germany, in France, or in the United Kingdom, or maybe the United States. And then we'll often file an international patent application, and that will then become national applications. And one of the real problems with these applications is that the moment you go into the United States, or into Europe, or into Australia, Japan, China, you have different rules apply. Some countries are much more open to computer-based inventions. Other companies are much more closed. Australia, very, very difficult to get a computer-based, computer-implemented invention protected as a patent. Europe, okay. United States tends to be a little bit, or was a little bit easier. China has become a lot easier. South Korea and Singapore is fantastically easy. So the question that we have to really ask ourselves all of the times is, how can we actually here, I think the majority of you have come from Europe, how can we really protect our ideas, at least in Europe, and also make certain that we can get patent protection in countries outside of Europe? And so our focus is going to be very, very much on the European system. So different countries treat differently. I've mentioned that. AI is often seen to be software based. It's an algorithm at the end of the day. It's a mathematical method. And we know that the United States has in the past few months or the past few years often rejected such ideas as being too abstract. And the European Patent Office rejects a software excluded from being patents per se, they call it. What they mean per se? Well, that means pure software can't be protected, but applications can possibly be protected. And I say our focus is going to be very much on Europe today. So if you really want to get to start ourselves off with a good patent application, one of the best ways is to start us thinking about what does the European Patent Office actually suggest to you? And they update their guidelines about every year, thinking about it, the decisions that have been made by courts, the current state of play of innovation in the field of artificial intelligence. And this basically has emerged into a consensus that you'll see here. So if it's an AI system alone, that's to say if it's a neural network, for example, or pure reinforcement learning, that will not get you a patent. It's fairly clear now in Europe. There's several decisions on that. We'll talk about them later on. But if you can find a technical application or a technical implementation, then at least in principle, you will be able to you will be able to do a patent application. Let's think about that. If I've got a pure artificial intelligence system purely implemented in software, just knowing data, nothing, there'll be results coming out of it, that will not be protected. Even if it's a pretty novel system of doing a pretty novel way of doing neural networks, for example. But the moment that I can do a technical application or a technical implementation, then I can get a patent. Now, that technical implementation is quite interesting because what that means is that if I can reduce the training time, if I can reduce the memory requirements, that's seen to be a technical implementation. What I've got to be thinking about, however, is demonstrating that. So just having a faster computer, that doesn't work. Just having faster memory, that doesn't work. What I really need to be able to demonstrate is that my invention enables this technical implementation or the technical application. So let's look at this, the technical application. Well, there's a few interesting examples. Some of these actually predate artificial intelligence, but we can certainly see that we have a very good guidance about where we can go. So, for example, in a heart monitoring, some of you may have heart monitors themselves. You'll certainly know parents, grandparents have had them. And what we do know is that AI is being used to identify challenges, illnesses in hearts. That is certainly something that can be protected. It's a technical application. So controlling specific technical system, controlling an X-ray apparatus, how to reduce the amount of X-rays, how to really focus the amount of X-rays. One of the most important areas is digital audio, video enhancement. Yeah. Our video conference today, very much implemented by artificial intelligence. The fact you can hear me quite well means that they clean up my voice, that they're making certain that we get the transmission going over. Now, previously, that was done fairly simply. You transmitted all of the data. We've now got data compressions. We're now working proactively to reduce the amount of data that can be done, is transmitted. And we have some incredibly valuable inventions that have come out of that. Inventions that are being standardized throughout the world with the new generation, for example, of mobile telecommunications, 6G, what new internet protocols that are being developed. And if you have one of those standard essential patents, as they're called, they are incredibly valuable. Separation of sources, speech signals, speech recognition, providing a medical diagnosis by an automated system. That's an interesting case because that's a borderline case. That really shows you where we have the borderline. If you process the physiological measurements and you use that to produce a diagnosis, that possibly can be protected. I'm just saying possibly here because there's a lot of prior art out there. But if it requires the intervention of a human if it requires the doctor not just to give a second opinion, but actually to give the diagnosis, then that's not protected. That's basically what we call breaking the chain. You need to have, from the start to the end, a technical implementation made through the use of artificial intelligence. What about the technical implementation of the mathematical model? I just told you about that. That's a bit more of a problem here. The mathematical method has to be specifically adapted, and you really need to be able to show how it improves the invention, how it improves data collection, how it improves the interaction between the hardware elements to do this. There's a couple of cases that we've seen at the European Patent Office where companies, applicants, patent applicants have basically said, we do this, or we, by the means of artificial intelligence, this speeds it up. Or we use a new mathematical method to reduce the amount of data that's required. That's potentially patentable, but in at least the United States, they will certainly be looking to try and understand what the physical, what the technical basis behind that assertion is. They won't just accept that this happens. And as well in Europe, the patent office often, in order to justify the inventive step, will actually ask you, well, this is obvious, isn't it? Just to do it like this and reduce the amount of memory. And if you say, no, it isn't, you will have to, explain why, and not just explain why using words, but actually try and produce some technical data. Now, this can be in the form of simulations. I've done that more than once, filed the patent office with the patent office to give you some idea of how the invention would work when it was typically implemented compared to the prior art. But it could also be, if you can get that data already into the original patent application, then you're in a much, much better position. So technical applications, technical implementations, both of which are really, really useful. So if we look at the guidelines of the European Patent Office, there's some really interesting concepts that come out of it. So we know that core artificial intelligence, sorry, that should be AI, not AT, that's going to be very, very difficult to protect. That tends just to be methods, new types of algorithm processing, new types of neural networks, new types of reinforcement learning. Natural language processing, that becomes a little bit more challenging. I'm going to go into that a little bit more in a moment. And classification system and recommendation systems, very, very difficult to actually get patents on it. So with the core AI, difficult to file, that comes from the European Patent Office's guidelines, often not technical enough. You might get it in some countries, and it's always worthwhile thinking about, even if you're told, that's going to be difficult to get in Europe, it's possible that you will get patent protection in some other countries. So you can often get it by overcoming detail, implementation system, the application of the algorithms, and also producing comparative data. And I haven't really put that in here, but in the next update, I'll do that. Natural language processing. This is a really, really interesting concept because we see here the differences between what can be protected and what cannot be protected. So when we talk about natural language processing, there's basically two elements to it. There's the element of the speech, the sound waves that are coming from my mouth, being picked up in this microphone here, being converted into electrical signals, being processed so that you can hear me better, and then going into your loudspeaker and coming out as sound waves. That is technical. It's quite clear. There's lots and lots of patents about that. But if we're talking about the concepts, we're talking about the content of the information, the fact that I am talking to you about artificial intelligence, that is not patentable. If we talk about how we see that various large language models can summarize content, that is not patentable. Why? Because that's not seen to be a patentable subject matter. It's not technical enough. On the other hand, if I talk to Siri here on my telephone, sorry, Siri is answering me, in fact, at present, because I get a response to that, how that response is generated would be seen to be technical. So we see that what goes on in a human brain, analyzing the context, we can't get that as a patent. But when you have this interaction with hardware elements, like Siri here, hey Siri, that would actually be seen to be patentable. It's a very subtle distinction, but quite an important distinction to think about when you want to protect your patent, patentable. And that's why I put it on this slide. Natural language understanding or comprehension, very difficult to patent. Probably almost impossible, but speech recognition, the idea of converting the sound waves into the electrical signals, into text on the screen, that would be patentable. What about classification algorithms? Well, there's even an interesting case on that. Classifying documents only in respect of their textual content is not technical, won't be patentable. Classifying data other than text data or linguistic data, that's more interesting. Sensor data, for example, when you've got a plant, a chemical plant, where you're picking up all of the sensor, that could be patentable. If you turn it and use it for a case where running, or was running, which was granted by the European Patent Office, where basically you were collecting a large number of sensor data and then looking at patents to see where there are potential failures, who seem to be patentable by the Patent Office. Classification of digital images, we've already talked about that. What about inputted data categorization, possibly? Yeah, there's quite a lot out there with the classification algorithms that we could certainly think of being able to use in order to get innovation there. One of the most valuable patent applications I think I ever did was analyzing X-ray images of human tissues in order to be able to identify certain types of human tissues. Really, really difficult, even for the skilled doctor, medical technician to do. An incredibly easy thing for a computer, a trained computer to do. Basically taking the knowledge of the medical technicians and the physicians, implanted into the computer, and then analyzing future X-ray images. It was also seen to be patentable by the Patent Office. Recommendation systems, they're pretty valuable. I think probably most of us have got an Amazon account. Most of us have bought things from Amazon. Most of us, every time we go into our Amazon account, get recommend something else, whether it's a book or whether it's a product that you've bought. Well, there have been attempts to patent that, but unfortunately, these don't tend to be patentable at all. They might be commercially incredibly important. I think Amazon said they have an enormous amount of extra work that comes in, or extra orders that come from recommendations, but they're still not going to be patentable. They're not technical there. So once we've decided what we can get as a patent, and I'm afraid that's just a few examples that we've got there, we then have to think, how do we actually claim it? And this is one of the areas where there's a lot of confusion. So you can write a patent on generating training data. Everything has to be new, novel, inventive. You can write a patent on training the data, and you can write a patent on using the trained model. Now, those of you who know a little bit about European patents will then come back to me and say, well, I can't have 3 concepts in one patent. And I know it's a bit of a problem within Europe. Different in the United States, by the way. So we have to think about this. Some people have then tried combining it. So you find patent claims where they have both the training and the use of the trained model in the same first claim. Well, that I can tell you is going to be a massive problem for the future. Why? Because the people who are training, the companies that are training the data, they tend not to be the same people who are using the data. Let's just take my medical image data that I spoke to about a moment ago. There was a research institute that actually trained it up. They licensed that to a commercial company. So we basically had 2 entities, the people who trained the model and the people who used the model, basically sold the software that was able to use the model. Now, if I'd written that patent claim together, then I'd have difficulty actually finding a patent infringer or a licensee for that patent, because there would very rarely be the same people doing both steps in it. But you see that pattern fairly frequently. So that's something we need to think about when we're writing patents. I've even had the European Patent Office come back to me, the examiner, suggesting that you might want to combine claims 1 and 5 to do exactly that. Claim 1 was training the model, claim 5 was using the model. And I refused point blank. And I said, no, I'm not going to do that. I'm sure that's going to be a decision fairly soon about whether that's basically the same as the plug and socket decision that people talk about, where plugs and sockets, yes, you can write one patent on that because they're complementary, which is my argument there. And in fact, it's been bought by most of the patent examiners that I've been working with. So I say each of these aspects really do need to have separate independent claims. Just going to skip over that slide there, simply time here. So then the next thing we need to think about is the inventive step. Is it obvious or not? So the test that we always use in Europe is not could the skilled person have arrived at the invention, but would they have arrived at the invention? That's a different question to be actually asked. And one of the things that's saying is, there's an enormous number of parameters that we're looking at, and it's really, really difficult for the human person to actually do this method or not. The Patent Office says, well, you could probably have hundreds of humans doing it, therefore it's not going to be inventive. But often I'm actually arguing that goes beyond the scope of the human brain. What we really need to do each time is to think about the problem that we're trying to solve and the solution that we're giving. And we need to really focus on that solution. The solution must be in the technical sphere. And it's not sufficient to say, I'm doing something very similar to what people have done in the past, but just adding an AI system. That's been rejected several times by the Patent Office. Patent Office is quite clearly saying just using an AI system is not sufficient. You need to explain how you're using it, why it brings benefits, and also how did you develop that AI system? That's one of the most crucial things that's been, you need to teach the public how this is actually being done. Now, there's an interesting discussion, and it's not on the slides because it's literally a decision that was published last week by the European Patent Office. And it's all about the question of, what about ChatGPT, one of the other large language models? Could ChatGPT come up with inventions or not? Is the skilled person the same as ChatGPT? Patent Office said, no, that's not the case. If you're trying to argue that something is obvious, it's not sufficient just to say, well, ChatGPT told me this was the case. Yes, but ChatGPT very much depends on the prompts that you make. ChatGPT very much depends on the amount of information that you've input and so many other things. What the Patent Office, however, does say in that particular decision is that you can use ChatGPT or one of the other large language models, whether it's Gemini, Copilot, or what have you. If you can then identify using those models a publication, another patent that has a similar sort of approach, that you can cite, but you cannot cite yourself exactly what ChatGPT told everybody. So that's just something to think about in the future. But it is often a real problem in the field of artificial intelligence that to actually identify what the advantages are, why it is technical, and to argue that in the patent application. Now, I've got 10 more minutes left on this. If anybody has any questions, please put them into the Q&A below. But I'm just going to talk about a couple of minor things, because one of the interesting questions that has arisen is it possible for the artificial intelligence language model to actually be an inventor or a creator? What happens about the documents or the photos that you generate through DALL-E or the other large language models? Is DALL-E an inventor and creator or not? Well, some fairly clear case law now from a number of countries that the inventor, the creator, has to be a human, quite clearly. Yes, the inventor, the creator, could be use AI system and maybe should acknowledge the use of the AI system. It's basically what the Germans have basically said here. But to say, this invention was created by ChatGPT, by Gemini, that is not going to work. It may be the case, but you are not going to get a patent. So what would you do in that case? Well, it seems to be fairly simple. It's probably the people who gave the prompt, generated the prompt. This probably should be listed as one of the co-inventors, if you like, but they're certainly the people who do need to be doing that. And what happens if you don't list an inventor? Well, a human as an inventor? Well, I'm afraid your patent is going to be refused. Quite simple. The other real issue is, of course, we talked a little bit about ChatGPT, and right at the start of the presentation, I talked about some of the IP and legal issues. So what we do know that ChatGPT has quite clearly used copyrighted information. Now, there's something called fair use in the United States. It doesn't exist in Europe, but this is what you will hear the people, producers of large language models continue arguing, where it's a fair use what we have done here. Well, there's a few cases now that are starting to suggest that that may be not the case. There's one case where somebody copied, for example, the large number of summaries of legal decisions in order to set up a competitive product. That's not finally decided, by the way, but the judge in that particular case has said that's not fair use. Fair use is not to develop a competing product. Fair use is to basically refer to the other product, to be able to cite it in an academic essay, maybe to make a comparison, but to produce a competitive product, that's not going to work. We have what's called in Europe the text and data mining exception, which does mean that you can use copyrighted data, the text and data mining, for non-commercial purposes, for research purposes. So a university can do it, a PhD student can do it, an MSc student can do it, but that's not for commercial purposes. And there's been a decision by the court in Hamburg, which I can't go into now, which has actually said, it's very interesting. Yes, if we're providing a database of images for research purposes only, that's fine. But if you then use that database for commercial training commercial model, well, we're not so certain about that. That's going to be a case that's going to run and run and run. And then, of course, the other question that we'll often have is liability. Yesterday, the European Parliament decided there was going to be no special liability for artificial intelligence systems. They're going to rely purely on the existing product liability regulations. It's probably good news because it would have been otherwise added an enormous amount of additional case law to where we're going here. So let's just conclude. And as I say, I'll take off the slides in a moment and see if there's any questions. We know that data can be protected. And that's going to be, we know that there is copyright for programs, and we know that patent solutions are possible if you can describe that problem solution approach that we have talked about in the future. So for those of you who have any questions, we can talk about it now. There's my contact details. Again, I'd like to acknowledge the support, the financial support of the European Commission through the European IPR Help Desk. In the preparation of this seminar, I'm actually an independent consultant in this. I'm delighted to answer any questions now. So these slides will be available afterwards, so you will have my contact details there. But if I'm going to stop sharing now and then move to the questions and answers, let's see what we've got. Yes, Björn actually asked whether they will share the presentation. Yes, I believe that the presentation will actually be available through the organisers at a later time. So I've answered that question. Does anybody else have any further questions? We'll often have some questions about where the best place to protect artificial intelligence inventions are. As I say, within Europe, we've got a pretty good balance, I think, working out where is a good place to do artificial intelligence, what's the right level of novelty and inventive step. The American US Patent Office tends to be, or has in the past been, a little bit more receptive to patent protection for computer implemented inventions. And there are certainly lots of countries around the world that actually do quite a lot more, more open to the protection of AI inventions. For example, Singapore and like. One of the other questions that I actually often get relates very much along the lines of, do I actually need to file the data set if I've used the data set for training a large language model? People then sort of say, well, you know, I have to file all of the necessary details in order to be able to be able to get a patent. I mean, the whole point about the patent system is very much the idea that you can use, you get the exclusive rights for 20 years in return for explaining exactly how you use the patent invention. And so people have said to, you know, does that mean you have to file the complete data set? No, the answer is you don't have to file the complete data set. What you do need to do in the patent application is explain to the patent office and the public through your patent description how you would collect that data, what type of features you extract from that data to use in your language, in your AI system, or that's a large language model or AI system. And based on that feedback, how you would actually, or that data, how you would actually train it. So I'm often said, you know, well, I've used this particular program from GitHub or from another commercial supplier, but you could use, at the end of the day, any potential program in order to train your AI model. Well, that certainly is true. But the patent office does want you to go into a little bit of detail. So if you're a software engineer, even if you say, well, I happen to use this particular program from GitHub, you probably should, but you could use other ones. You should actually say, yes, I use this particular program from GitHub in order to produce my patent application. Sorry, in order to produce my innovation. And therefore you cite it. What the patent attorney will do will often ask you, but what other programs could you use? Because what we do know is that every different implementation produces a slightly different AI model. It's not as though you're always going to get the same AI models. And the other thing that we've talked about a couple of times is the use of reinforcement learning, the idea that you get this feedback loop in order to do it. And there are different ways of implementing that reinforcement learning. It's not simply a case of saying, aha, I have reinforcement learning. You have to tell the patent office exactly how that works. So just last question is, but I got the data off the internet, that's fine, isn't it? I think that was known that, yes, even if you can download the data, even if you can scrape internet side pages, that's not sufficient in order to justify use of the data. This presentation is actually protected by my copyright. I drafted the presentation. I've licensed it across to B2B Software Days. I've told them that they can then supply it to anybody who takes part in this sort of webinar. It's not a problem at all. Really happy to do that, but it's still my presentation. It's, if you want to copy it, well, at least theoretically, you actually have to ask me to do it. I'm actually not too worried about doing something like this, but it's exactly the same things. If you buy a book on Kindle or on one of the other readers, you don't expect the fact that you can buy this data to present on your computer screen or your Kindle, whereas you could also buy the physical book in a bookshop. You don't expect to be able to use the data that you can present on the Kindle in a different manner than the way you can do it in the book. That's the case. So have to be a little bit careful about scraping websites in order to download data. So we're coming towards the end now of the webinar. It's been a pleasure to talk to you a little bit about artificial intelligence and intellectual property, but been able to give you a little bit of an insight into the way that this is working, into the way that the Patent Office thinks about artificial intelligence and how it can be protected. There's some brilliant resources on the Patent Office's website as well. There's a few webinars that you can listen to. It goes into maybe a little bit more detail about patenting than I've been actually able to do today, because I wanted to also remind you that we need to think about copyright and contractual law. So thank you very much indeed. Hope you have a good day, and hope you have a good rest of the conference. It's been a great pleasure to meet you. Thank you very much indeed. Bye-bye.